No. Good morning, Mr. Turner.
Good morning, my Lord. This morning, my Lord, we begin with Mr. Elliot Jackson from Children's Hearing Scotland.
Good morning, Mr. Jackson. Good morning. Right. When you're ready, Mr. Turner.
Thank you, my Lord. Good morning, Mr. Jackson.
Good morning, Mr. Turner.
Before we begin this morning, just a brief reminder that this morning's hearing will be transcribed. If you could speak as slowly and clearly as possible, that would greatly assist our stenographers. Excuse me a moment, I have lost the touch screen. Sorry, just a minor technical issue. Could you state your full name, please?
My name is Elliot Jackson.
Thank you. And what is your current position?
My role is National Convener of Children's Hearing Scotland and also Chief Executive. It's a dual role.
Thank you. And how long have you held that role?
For 5 years.
And how long have you been with Children's Hearing Scotland?
8 years in total.
Hearings Children's Scotland has provided a statement to the inquiry. That statement, my Lord, is reference SCI WT 06791. We're going to touch upon this morning, Ms. Jackson, a number of matters that are within that statement. We may not get through everything,
sure.
But rest assured that everything that is contained within that statement will be taken into account by His Lordship in due course. Before we start talking about Children's Hearing Scotland and about the experiences in the pandemic, perhaps I could just ask a few questions about children's hearings more generally. Of course. Could you tell His Lordship, I'm sure His Lordship knows, but for the benefit of others who may be watching, could you tell His Lordship, first of all, what is the purpose of a children's hearing?
The children's hearing system in Scotland derived from a report by Lord Kilbrandon in the late 1960s. The first children's hearing was in 1971. In Scotland, we refer to this as a unique system of youth justice and care and protection. And this was about the way that the hearing system is structured is that where children come into conflict with the law or have welfare needs, they come in front of a children's panel. A children's panel is made up of 3 lay tribunal members, which are also called volunteers, drawn locally from our communities of Scotland. The purpose of the children's hearing is in and around care and protection of children and young people. It's about considering the needs. There's a saying within the hearing system, it's about needs and not deeds. And those tribunal members will sit working with the family, the young person and professionals to establish a decision in the best outcomes, best interests rather, of that child or young person. Thank you.
If we could just unpack that a little bit, what kinds of issues would bring a child before the children's panel?
I suppose on the basis of offence grounds, so where a child or a young person commits an offence in the community and the police deem that to be of significance, they would refer the case to the reporter, and the reporter has a role of considering that case, working together with professionals, and what they would decide to do is whether to refer that case to a children's hearing. I understand you're taking evidence from Scottish children's reporters later on, and that's their role. So there's an element here of offence grounds. And back in 1971, the hearing system was probably 80% offence grounds and 20% I'm going to call welfare. And on the basis of the second role is about welfare, care and protection and welfare. This is where a child or young person in the community would be seen as having some welfare needs in the sense of potentially neglect, physical, sexual, emotional abuse, as an example. Perhaps not attending school. What are the reasons for this? What are the triggers for this? So, and then today, as we sit here now, the system is flipped. It's probably 80% is on welfare grounds and 20% is on offence grounds. And that shows the transition from 1971 to today.
In terms of the ages of children that end up before the children's hearings, what age of children do appear?
So from newborn children, in some cases we take action with parents around removal of children pre-birth, up until the ages of 18 for many children who are into the hearing system.
Is there any restriction in terms of that top end, the can all 17-year-olds effectively appear before the children's hearing?
It's a good question. The answer to that is no. If a child committed an offence who has not been involved in the hearing system at the ages of 16, 17 as an example, they would not come into the hearing system at that particular point. Had they been in the hearing system before and committed their offence when they were 16 or 17, they would remain in the hearing system. There is new legislation called the Children's Care and Justice Act, which will be implemented in 2026, middle of 2026, which actually brings the purview of the hearing system to bring those children of 16 and 17-year-old who have previously not been known to the hearing system into the hearing system at that particular point, and not therefore take the more judicial route via the courts.
You've mentioned that the hearing itself was conducted before a panel of
Sure.
3 members. What powers do those members have?
I mean, I would argue that in terms of Scottish public life, children's panel members have significant powers, from the ability to remove the child from the family to place into secure, to place into adoption, to place into permanence, would be at the top end. To the bottom end, as they would consider the case, and they would talk about perhaps being voluntary measures of care, where I would argue the state doesn't need to intervene, or to place what they call a compulsory supervision requirement, which places that child with an order that ensures that the family and the child or young person works together with social workers to work together to deliver a positive outcome or destination. And as part of that work here, the Children's Panel would review that. That would be in place for 12 months. And the panel would then periodically review that decision and review the progress of that case, often once or even more within that period of a year of the compulsory supervision requirement being in place. Significant powers, for in which we train them significantly in the role and contribution and execution of those powers.
Turning to the roles of the different organisations that are involved, we've talked about panel members. I will come back to them in a moment. But in terms of Children's Hearing Scotland, what is its role in relation to children's hearings?
As national convener, I have a role in statute to recruit, train and support panel members. These powers are shaped in the Children's Hearings Scotland Act 2011. And taking each one of these in turn is that we have, for the period that we're looking at today, we have around about 2,800 members of the CHS community. 2,500 of them are panel members that make decisions every day in Scotland. The other 300 are around leadership roles within the sector, roles for in which they provide observations and training. So again, that's the size and the scale. I annually recruit in and around somewhere around 500 to 550 panel members per year, in order, because we have got an attrition rate around about somewhere between 15 and 20% each year. So there's a significant role in recruiting, and we're recruiting citizens in Scotland. Again, and we'll come on to the detail about how we did that during the COVID period. Train is significant. It's a significant children's hearings system is the largest tribunal in Scotland. And as part of that, we take our responsibilities to train our panel members up into SVQ level 7, SVQ level 8, and around that. A panel member would be appointed, then they would undertake a significant amount of training, which is between 5 and 7 days, and then they have an ongoing period of review where I, as national convener, can determine whether that training is either voluntary or mandatory. A new piece of legislation, a new policy, COVID would be mandatory training as an example. So that's recruit, train and support. The support element here is that, again, across Scotland, is that we've got the wellbeing needs of panel members. Often panel members are attending particular hearings which can be tough to hear the stories of what's going on within families. It can be difficult to understand and comprehend some of the challenges that some of our children and young people face in Scotland. So there's elements here about the need for well-being to support them post the hearing, or pre-hearing, during hearing and post-hearing. So there's a well-being wrap around all of that. There's also the review that in our areas we have recognition. So it's part of my role is about recognition and rewarding. So it's all about what happens locally. I suppose in summary, my job is to support, motivate, lead, and try to move as many obstacles out the way to ensure that panel members can conduct their business at a hearing day in, day out.
In terms of the particular panel members that appear at any given children's hearing, does Children's Hearing Scotland have any involvement in that?
Yes. So, again, where panel members, again, members of the local community, 2 months in advance, as they would offer their availability to attend different things. So in terms of structure, we have hearings which cover the 32 local authority areas. Okay, but we have 22 areas for in which administer that. And each area would put forward their availability of their panel members. What we would then do is we would match the number of hearings that were presented, as an example, in Edinburgh, and we would then provide 3 panel members to undertake those hearings. It normally, traditionally works upon that a panel would sit on a morning or an afternoon, and within that context it would be that they would usually have 3 hearings within that session. So there would be 3 hearings in the morning, 3 hearings in the afternoon, but they would be replaced with a further 3. Hearings traditionally normally take in and around 45 minutes, but during the COVID period of time, which we'll come on to, they doubled in time to around about 90 minutes as an example.
Talking for the moment about the pre-existing position pre-pandemic, were there any restrictions, or were there any restrictions on the makeup of the panel that was being presented at a children's hearing?
Again, yes, there were. Again, back to the Kilbrandon report back in the 1960s, what it talked about is drawing citizens from the community. What they talked about, having a blend of a set of role models, being male and female. So within the context of the legislation, what it did was set out is that we had a gender diverse panel. So therefore we would have 2 women and 1 male, or 2 men and 1, and that was an aspect of the legislation which we'll come on to that we slightly altered. Interestingly, the makeup of the panel in terms of diversity is probably around about 70% women and 30% men. It's a constant challenge for the organisation to go out and recruit men. Many reasons for that, but again here, and looking at with the COVID lens here, that was a difficult feat to achieve in that context. But that's what it is: 30% female, 70% female, 30% men.
You've spoken there about the demographics. In terms of locations, you had indicated that these children's hearings sit across the 32 local authorities. Is participation spread evenly amongst those local authorities? Is it easier to find panel members in some than in others?
Prior to Children's Hearing Scotland being set up in 2013, as a brand new national body which was set up to create what they called a national panel. It was very, very difficult. So again, back pre-2013, you had 32 panels across Scotland which were affiliated to that local authority area. So using Edinburgh as an example, if I needed a panel member in West Lothian, the legislation precluded me from doing that because they were affiliated to that Edinburgh panel. The 2013 created what they call a national panel in which the emphasis was still about drawing a panel member or a volunteer from the local community, but it provided me, where practicable, to use that panel member in any other area of Scotland, which in the context of COVID was serendipity because it allowed us to have a little bit more flexibility and capacity to fulfil our hearings in those areas where I didn't have sufficient panel members to deliver a hearing.
Again, pre-pandemic for a moment, ordinarily, before the pandemic, did you find that you were having to use that national mechanism to find panels in a local area, or ordinarily are you able to use the local panel members?
We would have used the local panel members. It was used occasionally in some cases. It was certainly much by the exception where we had to do that, where, for example, panel members had to travel to a secure centre to have a hearing. It was in a cross-boundary area, but actually it was a feature that wasn't used predominantly before COVID. It's a feature now that presents itself more formally now.
We've spoken about the volunteer status of the panel members. You mentioned there were other volunteers. How are those organised?
So each of the 22 areas were managed by and led by what we call an area convener, drawn from the local community. Their role and purpose was to, again, use an example, Ayrshire. where they were responsible for that group of panel members. They were responsible for local training, local learning and development. They were responsible for the local rota, which is the issue which took panel member availability to the hearings. They were responsible for well-being and responsible for recognition. So they had a significant role, and they led that. We also had what we call panel practice advisors. Panel practice advisors, the key role was to observe hearings, but they're not observing the mechanics of the hearing. They're looking at observing panel members, and they would present panel members with a feedback sheet afterwards about their role, contribution, about their open questioning, their non-verbal and verbal communication skills, etc. And if there was any needs. So we had that. We had lead panel representatives, and they were responsible for, I suppose, the well-being and support, where a panel member had a very, very difficult hearing and where they obviously couldn't discuss it with their families. They would then pick up with their lead panel rep and they would discuss the case, and there would be an element here about unpacking and making sure that did that panel member require any further support that we could provide via Children's Hearing Scotland. So there was these types of roles there, and they provided significant. Of course, when the pandemic came, is that, again, some of those roles didn't do what we asked them to do. For example, panel practice advisors, there was no space for them at that point, so they were effectively furloughed.
Thank you. Turning back just to very briefly to Children's Hearing Scotland itself, aside from the panel members and the other volunteers, what is the staffing position of Children's Hearing Scotland?
The staffing position during that period was that the national team, if I could call it that, was made up of 40 members of staff, not a significant workforce. We're a very, very values-driven organisation, and everybody's contribution is felt and makes a huge impact upon the lives of children and young people. I suppose in terms of numbers, if I may, is that we've talked about 40 members of staff, we've talked about 2,800 members of the CHS community. We've also, they preside over 30, pre-COVID, it was 30,000 hearings, Mr Turner, and we've got probably around about 10,000 children who are the most vulnerable children in Scotland that need our help most. So in terms of the context of what we go on to discuss, that's the size and the scale of the operation.
I'd like to ask you very briefly about how children's hearings are convened, how they're instigated, if I may. Sure. How are they instigated? Who instigates a children's hearing?
So anybody can make a referral to the reporter. Predominantly, referrals are made by the police and social work, but of course health, school, education can all make referrals. The referrals are then considered by the reporter, provided by the Scottish Children's Reporters Administration. They will conduct an investigation into the circumstances of the referral. And they will then decide to take no further action, if that's appropriate, or in the case where we get involved, is that they take them forward to a children's hearing. When they get referred to a children's hearing, the first job is to establish the grounds of that hearing, so that everybody understands the rationale about what that child or young person. So the first hearing would be where the child and your young person, together with their family, social worker and other professionals, would attend what we call a grounds hearing. And at that point there, the chair of the panel, the volunteer, would then put the grounds to that particular child or young person and the family. Young people, depending upon the age, I think we talk about under 6, it would be difficult for a child or young person to accept the grounds. However, if they're older than that and their family accept the grounds that they committed this offence at that particular time, as an example, and everybody agreed with the grounds, we would then go on to have a substantive hearing, which would then look at the well-being needs of that child or young person and work together to a substantive decision. In the event that the child, young person and or deed the family, or it was a child a child under 6, those cases would be referred to the Sheriff Court to establish fact at that particular point. So they would go off to the court, and then depending upon the Sheriff deciding the fact, they would then come back as fact for the hearing to then convene a substantive hearing to look at the individual cases. Again, back to that point here of the philosophy of the child's needs and not their deeds.
How quickly does this all happen? Is there any time limits in terms of how quickly the reporter has to bring these matters forward?
Good question. Yes. From the point of referral, the reporter has 50 working days in which to consider that case. So at that point there, they would instruct social work department, as an example, and any other agencies to provide them with reports about what's going on within that child's life. They would then consider that. They have a decision-making framework in which they would then follow, and then they would bring forward a hearing within 50 working days. So that's a key point that they have.
You've mentioned a number of different stages in terms of the child coming back before the panel. First of all, for grounds that could obviously then go off to the Sheriff Court and then come back. Equally, we talked about reviews taking place within 12 months. Is it the same panel that's convened each time the child comes back?
Ordinarily, no. There is a process for in which we call continuity, where in some cases the child who has attended the hearing and indeed the family have made a connection with one or all of the panel. Sometimes it's really, really helpful that that panel are reconvened into the next hearing. The rationale behind that is A, they've made the connection and they understand that. Secondly, is that the hearing can often start off at a higher point. So therefore, in setting out the decisions and reasons, they can say, right, at the next hearing, we're going to focus on that. And then third aspect, and I think children and young people recognise this, is that often that in terms of social work reports and panel members, it has the most intimate of details shared with the panel. And again, part of that work here, children and young people, perhaps they don't attend their hearings because it's too traumatising. So part of that work here is you don't have to go back over the chronology and potted history of that child. You just focus and concentrate on their needs, as an example. So there are many really, really good advantages of continuity. It's not ordinarily done. It's now probably done more than it was 5 years ago now, because the benefits of the family, the panel members, and indeed children and young people bear that out.
I'd just like to ask you now about some of the practical arrangements in terms of the hearings. Physically, where are hearings held? Again, pre-pandemic.
Pre-pandemic. The Scottish Children's Reporter, or the principal reporter, we are two statutory duty bearers within the same system. The responsibility of the principal reporter is to, as well as consider the hearings and make a decision on whether to refer to there. The other aspect is they've got the opportunity, they've got the statutory responsibility to schedule hearings and to provide an estate for the purposes of hosting hearings. In the context of pre-pandemic, I think there was something, and colleagues may have other data in a region, I think there was something around about 45 sites across Scotland, but they would be physical properties, some wholly owned by the organisation, others would be on a sessional perspective. There is very clear legislation that a hearing cannot be held in a courtroom or anywhere like that, but it's important that they are. So they're all hearings. I would argue that probably 100% of hearings pre-pandemic were held face-to-face in one of those locations.
Were there any virtual hearings before the pandemic?
I don't think we would call them virtual hearings where we would have professionals, the child and young person, and panel members on a hearing. I can't recall that. Latterly, where we did have some online hearings is where if there was a parent who was incarcerated, sometimes the Scottish Prison Service would seek to have the mum or the dad using online hearings to come into the hearing from the establishment. So that was the use. It wasn't. We didn't routinely ask panel members to come in online at all.
Hearings were previously taking place face-to-face. Given what you know now, post-pandemic, do you see that as an important factor in terms of how hearings are conducted, or do you feel that they could be conducted virtually with no distinction?
I think when considering in the statement we talk about lessons learned, I think children have often said to us constantly over the last 10 years two things. First of all is that the room is full of grown-ups and sometimes their voice can get lost in the context of a physical meeting where you could have up to 15 people, where you have the family, extended family, you have social work, you have health, you potentially have education, and you have legal representation in there. And lots of young people feel, despite panel members being able to manage that hearing, it's sometimes very, very difficult for that to happen. Children and young people have often told us as well is that when they're at school, whether it be primary school or high school, there is a stigma attached to attending a children's hearing, where the social worker would turn up and take that child or young person out of school, and everybody knew where they were going to their hearing. And at that point they were saying, can we think about something differently? And then when you look pre-pandemic at the opportunity for a child or young person to present from their school, from a private environment, head teacher's office, etc., it felt unachievable before the pandemic. Now it is achievable. And that thing, so again here, that's something that will remain with us as a lesson learned. We'll have that. I think we need to find the balance. So there's 3 types of hearings that are now commonplace within Children's Hearing Scotland. One would be a fully virtual hearing, where every aspect and every member of the hearing would come in virtually. Secondly, is that you would then have hybrid, where some people may be in a room physically located, of course, and then the last one would be face-to-face. I think we've not probably found the balance between what it is that we want and what it is we need. Panel members would often say that it's very, very difficult to elicit the views of children and young person via an on-screen. They've had some notable successes, but it's difficult. Panel members perhaps talk about the non-verbal communication and cues that they see within a hearing. These are important in the context of understanding where that child is. And I suppose sometimes when you've got a room with 15 people, it's very difficult to manage. So, but as far as going forward is concerned, hybrid, face-to-face and fully virtual will now become a significant part of the hearing system from now on.
You've mentioned that there can be a significant number of people. We've talked about panel members, the reporters, you've mentioned their health, the children themselves, the families, legal representation, and you've just mentioned a number there, 15 as an example. Is that a fairly ordinary number in terms of the sort of, is it representative of the kind of numbers of people that would appear in an average children's hearing? It
can be. It's grown. I mean, I would say over the last 10 years it's grown. A lot more families have legal representation, and in that context you can have a legal representative for the father, for the mother. We have advocacy for the children. So in an attempt to make sure all rights are preserved and the voices are heard, etc., it extends the number of people who have a view on that child or young person. Panel members are trained, and there's a number of wonderful examples of where we say we kick off the hearing with the 15 people, and then they segment the hearing, saying, listen, we're going to hear from the social work first, then we're going to hear with education, etc. And they then begin to manage that hearing by bringing people in, which helps the child or young person gain that sense of agency over that hearing. That happens in a number of cases. Online, I think it got better because we got used to the mute button, where we could then bring in colleagues to speak. I don't deny it's a very, very busy place, and despite the best trained panel member who is child-centred, it can be really, really difficult in hearings. And an element here where it's emotional. A hearing can be very difficult. It's where there's a lot of emotion in the room, and lots of people try to get their views across there. You've got solicitors holding to a legal perspective. You've got social work holding to a softer perspective, I could call it that. So that, again, here there is a bit of a challenge within a hearing. It's got everything.
We've spoken about some of the procedure and some of the process. I won't reiterate that. You've talked about the fact that the grounds could be considered, and then the substantive disposal could then be approached. What are the disposals that are available to the panel members?
So we've discussed the grounds when it gets established. In terms of a substantive hearing here, again, there are, so back to their powers, a compulsory supervision requirement. If it's going off to the court, as an example, there's another power which is called an interim compulsory supervision requirement, an ICSO, if I may, and that protects that child or young person whilst that case goes off to the sheriff. So there's again a decision to be made in and around that. In terms of disposals, well, again, here it could be that after review and after confirmation from the child, family and the set of circumstances provided via the social work, it could be a no further action, or it could be voluntary measures, so where the hearing would have no involvement in that child's life. And that's an important stage, that they may have been referred to the hearing system at a point of crisis. And perhaps that crisis is now past and sustainable measures have been put in place, so therefore there is no need for state intervention. And then, of course, there's a compulsory supervision requirement in terms of where that would be at. And these include often different ways around. There's conditions within that which could be about secure accommodation. It also talks about decisions around contact, etc. So there's a multitude of reasons and decisions that we make.
Just to pick up very briefly there, in terms of the sort of extremes, you mentioned there, effectively, this is probably a poor word, but incarceration is one disposal available to the panel in circumstances. And similarly, when you're talking about contact, that's removal potentially from their family situation.
These are significant decisions, and panel members ponder those decisions. They get the paper 7 days in advance and they pore over the case. As part of that work, they will also create a series of questions to assure themselves that that is the right step. They will then challenge those decisions. Remember, they are independent decision makers, and the social workers will make a recommendation in the report. And in many, many cases, those recommendations will be followed. But before they go to that decision, it will be up to the panel to ensure from all the professionals present that that is in the best interest of their child, for that child. In many cases, where you place a child in secure is often for the child's safety. More than anything else. And again, back to that bit here about the notion of the unique hearing system. This is about safety and child protection. It's not meant to be punitive.
I'd like to talk to you now about some of the changes that took place in consequence of the pandemic. Before I come to those, could I just ask you, were there any plans, pre-pandemic plans in place, either Children's Hearing Scotland itself or the Children's Hearing system more generally that you were aware of were in place to respond to something like the pandemic?
Business continuity planning is a feature of every public body in Scotland. We are always asked to make sure our plans are up to speed, and we are held to account by our boards or audit committees to make sure our business continuity plans. We do tests and scenario planning once a year around our business continuity planning to make sure it's up to speed. We tested the catastrophic failure of our IT systems. That was the norm. What happens if our systems go down? How do we respond? How do we get panel members to a hearing where we've got nothing else? We can't see anything. We're blind to that. We also looked at other aspects of what happens if there's a fire in the head office and we can't get back to head office. But never did we do any testing on the effects of a pandemic. I suppose my response is that there's features of both the head office burning down or our systems that you can take and that we used, because essentially at that date in March everybody was out of the head office anyway, and we had began to look at how we would go forward anyway, and I suppose we'll get onto it when we talk about how we provided laptops and staff about when they moved out. But certainly there was no dedicated work on the impact and business continuity of a pandemic.
Turning to the changes that were made, most obviously, lockdown was a severe change that we know occurred on the 23rd of March 2020. I suppose it's self-evident that where one is not locked down, one is not restricted, or there were not restrictions the same way. What were the changes that were made to address that? I should say, I will come on to the particular legislative points in a moment, but more generally in terms of the practical arrangements that were made
Sure.
for the hearing?
I suppose three main aspects then. First of all, if you look at the impact upon staff, we have a national office in Edinburgh, but our staff are based all throughout Scotland. And as part of that work there, everybody had laptops, everybody was mobile and everybody was portable. Serendipity would say that in January of 2020, CHS implemented Teams. Again here, when you look back at that as an opportunity, which served the organisation well over the next 2 years. It was an incredible accident in terms of where that was at. So we had dedicated systems in place where not only could we communicate via email with members of staff, but we also could have the face-to-face communications and online communications. So that infrastructure was present. So I would argue that on the day of the lockdown was announced, the impact upon staff at that particular moment about having the capability to do their job was relatively smooth. If you look at panel members around where they were having to secure and protect children immediately, the immediate reaction there was, again, so for example, within the first 2 weeks, when you've got a compulsory supervision requirement, as I explained earlier, is in place for 12 months, there might have been a hearing the following week after lockdown, and they may be scheduled to have attended that hearing. And we had nothing, we had no infrastructure at all to make sure that that happened. And our primary job was to protect that child. So during that period, there was lots of telephone hearings, and part of that work there was to engage with the family, etc., with a view to ensuring that they were protected. So what we then do is continue that supervision requirement, so therefore you had that. There was a considerable amount of work done with our partners at SCRA, looking at online solutions to flip that. How were we going to work together, that they could schedule the hearing, we could get the papers out, because back to the pre-COVID position is traditionally hearing papers would have been posted. Now, in hearing papers, using another generalist example, it could be up to 150 pages of detail about that child's life. What we had to do is flip them onto an online solution. So you had the papers going out 7 days out, an online solution, and then what we had to do is find an online solution which allowed child, family, professionals, as well as panel members, the reporter, all to obtain that. So there was considerable amount of work that we had to do that. I would also argue that in terms of leadership, I don't know of another statutory organisation which delivers its services through volunteers in terms of the way of making decisions. But another role we've talked about is the area convener role, where there are 22 citizens across Scotland who essentially run the local hearings. And part of that work there was about, I needed to set up an infrastructure which allowed me to communicate with them about the direction of travel of the business and where we're going. My role there was to lead, my role there was to motivate, and my role there was to inform. We also had some other technical challenges, is that in the context of creating an online environment, at this particular point, panel members never had any devices at all. They didn't need them. They would attend the hearing. So we had to look at the provision of how did we get panel members to connect. And then in the early days, and I would recognise panel members were using their mums, their dads, their child's iPads, doing various different things, any particular aspect to be able to log into the hearing. And as part of that work there, we then had to provide them with devices. We made a fairly significant decision, which was speedy, and it was based upon investment, that we then contacted an organisation and we rushed out 2,000 Chromebooks, as they became now, which were laptops to our panel members, which allowed them to engage. So there was multiple aspects that we had to go through to make sure that hearings could take place and children were protected, especially at that start, and then continue to get better.
I'm going to pick up on a few things that you've said there. Picking up on the Chromebooks aspect, first of all, sure. Did you experience any issues with the devices themselves in terms of lending them out?
We did. Again, it's back to that particular part about procurement. So the Scottish Government set aside a number of different procurement rules that allowed us to procure in arguably days and weeks rather than months. We looked at evaluating the Chromebooks, and of course we were competing with NHS and every other public body who was reaching for that. Before we decided on Chromebooks, and this is probably worth mentioning, is that we were, as part of the work to enable panel members to become technically enabled to attend their hearings, the initial response is that we would then pay for high quality installation of Wi-Fi. That was first thing. That's what we thought would be good, and we could organise that. Second aspect is, rather than providing, because at one point we weren't sure that we were going to get 2,000 devices at that particular point. So what we had looked at was actually providing, partnering up with a high street store and then giving them a voucher for in which they could then subsequently go on and buy a device around all of that. We took legal advice about the impact of that, and of course legal advice came back to say that that would incur what they called a benefit in kind tax, which would then, for my purposes to get hearings, would bestow a need for every panel member to have to contact the tax office to talk about the benefit in kind. So therefore, against that, I suppose, high ambition of trying to get that through there, we had to resolve back to Chromebooks. I would describe Chromebooks as a minimum viable product. They were what were on the marketplace, they were there, they worked, they delivered on it. It was certainly no frills around that, and we subsequently made a decision to move away from Chromebooks and to move on to another set of devices. But certainly, they were there. We also had to look at the infrastructure, about how do we get them out to those 2,000 panel members, and again, that was difficult. Because what we needed to do, speed was of the essence. Most people were saying that they could use their own laptop. Everything was web-based, so it wasn't as if we were using the laptop. Everybody was just using the internet to access the hearing. So we had enough going on to do, enough people talking about that they had their own devices and could use their own devices to fulfil that initially within the first 8 weeks of the system. Then after that, the Chromebooks really began to take place of other family devices.
When panel members leave Children's Hearing Scotland, do they hand those back?
They do, and I would recognise the challenges of panel members. So we've got 2,000 devices going out to the 4 corners of Scotland, and there's an investment, and there's a return on investment, etc. In speaking to the board and the Scottish Government around all of this, it was just important to get the devices out. Time was more important than the scrutiny, etc. around all of that. If a panel member was to leave for any different reason and they had a Chromebook, there was clear instructions for them on how to return that. In the maelstrom of managing in a pandemic, I'm not sure every laptop that we had returned to us, as an example. But in order to cater for that and to ensure that the governance around the systems is that our supplier would then effectively kill that laptop in terms of so there was no information governance risk, there was no anything like that. So I suppose we had a safeguard in relation to that. We've now got far more slicker procedures and processes which allow the exchange of devices in a far more formal way now.
You mentioned the ambition to assist with panel members' Wi-Fi and their broadband and paying for that. Were you able to do that?
No, we didn't. The legal advice was very clear on that bestowing this benefit in kind would incur significant challenges with the tax office at some point. We could have been a bit more braver and courageous in saying we'll take on the tax officials at a certain point. It was important. However, faced with the prospect of a solution of 2,000 laptops, an infrastructure which delivered them for us again, and the speed, had Chromebooks not been able to be delivered within the framework and time that we needed them, we would have had to have considered the alternative. But as a consequence of being able to deliver, we chose that option.
How did panel members find the change to the digital environment? Difficult.
That might be an understatement, but what you had here is you had a process of preparing for a hearing where you had, and using my earlier example of 150 pages, they would arrive with a hard-pressed postman who were providing a very, very detailed pack of papers. And normally they would be, at the longest, 7 days in advance, certainly 5 days in advance. You would sit down, you prepare your hearing, you prepare your notes around these papers. You would attend the hearing, your papers would be on the table, and you would have a recall around all of that. What we then did is we essentially moved to a process of where those 150 pages were now essentially a pack of PDAs. It's called the Hearing Information Pack. And the Hearing Information Pack was electronically sent to panel members. I suppose the benefit of the Hearing Information Pack from a technological perspective is that papers between the transit from the office or an office to the panel member's home could not get lost, and these panel papers dealt with really significant pieces of information. But I suppose the second bit here is that panel members got papers even earlier, because they were emailed to them and they didn't have 2 or 3 days in terms of the post. Panel members would then go through, again, the Chromebook was used in preparation. You would then read the papers and you would go through the cases, you would prepare your notes. So that was the first challenge. That that panel members had to face. Again, that was difficult. And we probably, during the period of review, we lost around about 1,600 panel members in that time. Exit interviews that I looked at certainly were technologically was an issue, is that some panel members said, actually, it's a step too far. I can't do this. I don't want to do this. Therefore, more longer-standing panel members said, actually, I'm now not going to do that. Such was the change. Panel members would then go into the hearing, and therefore they would use a Chromebook to access the hearing. Back to our example of 15 people in the room, you've got 15 faces, you're trying to focus on a child and young person. Panel members had to wrestle with 3 things. First of all, is they had to wrestle with the changes to the legislation, and I know we're going to come on to that, Mr. Turner. They had to change, and the policy and practice issues of those legislative changes. So that was the first thing that they had to wrestle with. Second challenge that they had to wrestle with the tech. We've all been in meetings where we've been speaking when the mute button's on, etc. They had to challenge about how do you run a hearing remotely. We had a real diverse mix of experience of panel members and their abilities to do that. That was the second thing. And then, of course, the third thing was that real skill about trying to elicit the views, particularly of young people, through the medium of a screen. And that's a real skill. So they had these 3 challenges to go through and do this. And perhaps the other issue here is the tech was not reliable. It wasn't consistent. There are many, many stories of where panel members would be, because either the quality of their Wi-Fi connection from different parts of Scotland wasn't strong enough to sustain the hearing, or secondly is that the tech simply timed out. And in that way, they fell off the hearing. And there's examples there of whereby panel members would then try to get back on, many of which did get back on, but others who didn't. So again, here there was these kind of 4 challenges around what it was. So it was a difficult start to that against these different things. I think panel members would say, and of course the last part there is, I talk about pre-pandemic hearings were 45 minutes. Invariably, hearings would double up to 90 minutes and more, as they took more time to seek the views and needs of that child. So it was a difficult time.
I'm going to come on now, if I may, to some of the procedural changes that took place.
Sure.
You've mentioned 6 in particular in your statement, which I'm just going to address with you now, if I may. You mentioned earlier in your evidence that compulsory supervision orders were 12 months prior to the pandemic. Was there any change in that regard?
Yes. So again, working together with the government. So as well as flipping the system online, and a significant part of the organisation was prioritised upon that. A lot of our practice colleagues were looking at working together with government about what opportunities and changes to the legislation that we could bring in, which would then provide flexibility to the organisation, and secondly to safeguard children and young people more. These discussions were wide and varied, and they were lengthy. And in the example of the first example you choose here about a compulsory supervision requirements in place for 12 months, it was shifted to move to 18 months. The benefit of that, it then provided the reporter simply to extend there. So therefore the child or young person didn't have to come to a hearing. The reporter took that decision in law, which extended that. So that presented a real opportunity in space for the system to catch up with how a hearing would actually happen. So again, that one was particularly helpful. The second one that we've got there was around about the interim compulsory supervision requirement. And that, again here, where a case is going to the sheriff for grounds and we need to make an interim order, that's normally 22 days. That was extended to 44 days. And that afforded the court more time to get their decision and for the sheriff to make a decision and for it to come back. Again here, safeguarding the child or young person. I think these were excellent changes to the system, and they took some of the pressure off it and provided security to that child or young person.
You've mentioned there two of the 6 things that you've mentioned in your statement. So the extension of the compulsory supervision orders from 12 to 18 months and the interim supervision orders from 22 days to 44 days. You've mentioned those were benefits for the system.
Sure.
Were there any impacts on children from those changes?
I think especially the first one, about 12 to 18 months in making decisions, I think I would argue that children and young people stayed in the system, some children stayed in the system longer than was necessary. But the key safeguard in and around all of this is, notwithstanding the reporter making the decision or the panel extending it for 18 months here, is that child, young person and the family, or indeed social work, had the opportunity to bring a case, so to ask for a review. So notwithstanding the arbitrary decision made, is that the child's rights and indeed the family and social work, they could bring back that case to say, actually, things have settled, this is the now position, and in these cases you would then say, fine, agree with that, you would remove the compulsory supervision requirement. So whilst it provided that umbrella of safety and comfort, there were mitigation for in which that child, young person, the family, or indeed social work could bring the case, and you would hear that case.
The next thing I wanted to address, you mentioned earlier in your evidence the pre-pandemic requirement for gender balance on the panels. Was there any changes to that?
There was, and that one there which allowed us to remove the gender balance, the need for gender balance. And that allowed us more flexibility, again. Back in 1971, when the first hearing vehicle, Brandon, the rationale here was that a child or young person of that time would see role models of men and women. I think we're in different times now. It was seen as being a bit of an obstacle for us in some ways, back to the point where 30% is women, 70% is women, 30% is men. And I think what we did here is we provided greater flexibility. Of the 16,000 hearings in that COVID time that we're talking about here, mixed gender panels, panels with a single sex, happened in 309 cases. So it's a small fraction of those cases, but still within these 309, it might have meant that the hearing going ahead or not going ahead.
A similar change, not a similar change, but another change to the panel members was you mentioned that ordinarily or pre-pandemic 3 members were required. Were there any changes to that requirement?
Yes, absolutely. Again, this was a key enabler. Although we've got the national panel and we had 2,800 panel members, what we had was some panel members saying, I need a break from this. So whilst the 2,800 is the top level figure, we had many categories of panel members below that who were saying, I just can't deal with this right now. Still want to be a panel member, but I won't. So the numbers began to reduce. In some areas where we were trying to, so whether it was a child protection case, which we needed to scramble 3 panel members together quickly, or other substantive areas in some of the more rural areas, we had the opportunity to go with less than 3 panel members. It was always our ambition to try to secure 3 panel members, and where we couldn't do that, we would go ahead with less than 3. And a number of occasions we used 2, and I think in a very, very tiny amount of cases we used 1, depending upon the circumstances.
We talked about who ordinarily, or again pre-pandemic, would be attending the hearing, and one of the categories we talked about was obviously the child or young person themselves. prior to the pandemic, was that a mandatory requirement or a mandatory right, if I can put it that way, for the child to attend?
Yes, today there's an obligation for the child to attend, unless that, and where the child doesn't want to attend for whatever reason, panel members apply a test to that, whether to excuse the child from attending. So I suppose pre-pandemic there was an expectation, obligation of that child to attend, and then in the COVID legislation, that obligation to attend was removed.
You've said removed there. As of today, is that obligation back in force?
Yes.
In your view, did that have any impact on the children?
Again, back to the point where children and young people find attending a hearing can be a negative, in a case harmful experience. That's what they would say, and I think we doubled down on seeking the views. So in order to maintain their Article 12 rights about being heard, is that there was three things that we did. I suppose is firstly is in the new legislation or any policy change, the Scottish Government or any public body has to undertake what we call a children's rights impact assessment. So again, for child and young person part of the COVID-19 Act, we had to go through a child and young people's assessment. As part of that work there is a preset of questions which pushes the organisation into asking itself a range of questions to ensure that we preserve the rights of children and young people. So every single step. So where a child didn't attend, there would be three things that we would do. One is that we would constantly provide them with letters of support and asking them to write to the panel chair. What was their views? What did they think? Etc. That was first thing. Secondly is we promoted the advocacy provision. There's a national advocacy provision across Scotland where children and young people can seek the support of a hearing, pre-hearing, during the hearing and after the hearing. And it's often advocates are an excellent source of providing the information to the panel on behalf of that child or young person. We also worked together with social work, local authority social workers, because it was important that in the report that they present to the hearing, the views of that child or young person have to be implicit in that aspect there. So what we then look to get that views. So these are the things that we tried to ensure were in place that didn't affect the rights. One positive element would be back to that example of whereby there's a number of young people who don't attend their hearing because of the stigma. Primarily because we had offered them an online solution. It's what they do. They use gaming, they use social media, etc. That I would argue that there's a number of young people in particular who actually engaged in their hearing primarily because they didn't have to sit in a physical location surrounded by grown-ups. They could sit in the comfort of their own home and present their thoughts, and then once they're provided that information, they could either go off screen or go to mute. So therefore, I would argue that in some ways it actually propelled the views of children and young people in a slightly unintended way, if that makes sense.
The final legislative change that you make reference to in your statement is the allowance of electronic signatures on supervision orders.
Yeah.
You've mentioned in your statement that you see that as a benefit. Has that benefit been sustained post-pandemic?
Yes, it has, yes.
I'm conscious of our time. We could probably talk for a significant longer period, but we are running out of time. What I would like to do now is, if there is any other significant matters that we haven't had an opportunity to touch upon, potentially if there's any lessons that you think His Lordship might wish to consider, now would be just give you that opportunity maybe to mention those. Okay.
I suppose three things strike me in terms of kind of reflections around that. In terms of the role and contribution of staff, is that we all now have 40 members of staff, and I suppose the role and contribution that they played was incredible. We had we had wellbeing needs of our own staff that we had to protect and around all of that. Also, the Children's Hearing System, or Children's Hearing Scotland, is only one part of a significant child protection infrastructure. Our colleagues at social work, colleagues at police, colleagues at SCRA. And I suppose it's important to recognise the role and contribution of the system collaboratively working together to fulfil these. It's easy for the panel members to make a decision on a child or young person, but they need confidence that that decision will be implemented by our social work colleagues. And I suppose that worked. I suppose if you look at, and I'm sure, Millard, you've heard lots of wonderful testimony from individuals who have gone the extra mile within the context of COVID. I said earlier, I'm not aware of another organisation, a statutory organisation, which delivers through volunteers. The role and contribution of panel members locally and the sense of community locally was simply outstanding. We had wellbeing needs, etc. I suppose I would describe their role as quite remarkable. In the role of COVID, when there was lots of other challenges around with family, with homeschooling, etc. They prioritised children's hearings and the child protection of children. So I think, again, that's noteworthy, I would argue. I'm certainly proud of them, I'm sure Scotland is as well. In terms of lessons learnt, I think we've now gone from a strictly face-to-face physical model to hybrid, to face-to-face and to online. I think these are good. We're getting better and better. So there's a lesson learned there. And I suppose, but that's another thing which is linked to risk and bravery. I think before the pandemic, we would be cautious about moving there. And I think what we have done is we've proved the concept that working together within the public sector, we can deliver large-scale change and quickly. And that was an example. So again, here, there's something round about organisations and their risk appetite. Maybe one thing is that we had area conveners, and these are area conveners. So I had an area convener in Glasgow who's in charge of almost 450 panel members. And those colleagues were on a call with me every Wednesday. To interpret the government legislation, interpret the government guidance, look at the intended consequence of that guidance and the unintended consequence of there. Now, these are 22 wonderful citizens of Scotland, and they are worth mentioning. 45 straight weeks they were on that call, and these are mums, dads, grandmas, granddads, etc. And they prioritised the system for Scotland, and I think it was really, really important. One of the aspects of that is that, if I may, review dates were really, really critical to us. You'll recall that the early part of the pandemic, we seemed to be moving on a week-to-week basis with different advice and different guidance. And as you got further through the pandemic, the stability began, if I can call it that, the stability began to emerge. The notion of review dates really, really helped us, because it was a point in the sand that there was an element of stability. We wouldn't be looking at something until we got to that particular element. So I suppose their procurement rules, I think the government set aside procurement rules, and these are incredibly enabling, and we're working hard with the government to find a balance around that. And maybe just finally on the lessons learned is probably just to reflect that some outcomes for children and young people were improved by not being part of the hearing system, but they didn't have to go to school. They didn't have the state intervening. They had more family time, etc. So I suppose the lesson for me there is that sometimes the state's involvement, including the hearing system, despite our needs and not deeds approach, sometimes can have negative impact upon those children and young people. So I think that's important, that in terms of the role and contribution of the state in children's lives. So that would be some aspects.
Thank you. My Lord, unless your Lordship has anything further.
No, thank you, Mr. Turner. No, thank you, Mr. Jackson. I'm very grateful for your evidence. 12:30. Very good. Thank you. Good morning, Ms Traynor.
Good morning, my Lord. My Lord, this morning we have a panel of witnesses from the Scottish Children's Reporters Administration.
Good morning, all.
Good morning.
Right, when you're ready, Ms Traynor.
Thank you. I wonder if the sensible place to start might be if you can introduce yourselves. Could you perhaps say your name and your role within the organisation? And we'll start with you on the left, Mr Hogg.
Thank you. Good morning. I'm Alistair Hogg. I'm Head of Practice and Policy at the Scottish Children's Reporter Administration.
Good morning. I'm Susan Deary. I'm Head of Human Resources at the Scottish Children's Reporters Administration.
Hi, morning. I'm Helen Etchells. I'm the Senior Operational Manager for North and West Scotland at the Scottish Children's Reporters Administration.
Thank you all. You jointly have given us a statement, and the reference number for that statement is SCI WT 0548 and then number 1. That statement, I think, was compiled with input from each of you with the opportunity to review it and make changes to it, and it will of course be considered in full by the inquiry along with other supporting documentation which you've provided, which has been very helpful. You are aware, I think, that we've heard evidence this morning from the National Convener and CEO of Children's Hearing Scotland, so the scene has been set somewhat in relation to how the hearing system operates. But I wonder if I can start by asking you to describe where the Scottish Children's Reporter Administration, or SCRA, sits within that system.
I'll answer that one. So the Scottish Children's Reporter Administration is a statutory body, and its principal purpose is to support the functions of the principal reporter. And we operate with a number of children's reporters whose role I can describe if you wish me to do so. The principal reporter has to receive referrals in relation to children who may require compulsory measures of supervision, and decides children's reporters are essentially the gatekeeper to the system to determine which children may need compulsory measures. And the principal reporter also has a duty to arrange hearings and also to provide the premises in which hearings operate. But I can get more when I describe the role of the reporter.
Of course. So we've heard the Children's Hearing Scotland is responsible for the provision of panel members and the giving of information and the training and recruitment of those panel members, who we've heard are volunteers. You've described the children's reporters being responsible for arranging hearings and facilitating hearings taking place. Is that right?
Yes, that's right.
And you helpfully, I think, within the statement that you've given at paragraphs 8 to 14, describe some of the roles and duties of a children's reporter, but can you briefly summarise what is the role of a children's reporter?
Of course. So essentially, children's reporters operate with the delegated authority from the principal reporter, so everything we do is on behalf of the principal reporter. We receive referrals in relation to children over whom there are concerns. Those are usually welfare concerns. We receive referrals can be literally from the day that a child is born up to the age of 16, and sometimes in 16 and 17-year-olds as well in certain circumstances. I'm sure you're aware that the law's about to change in relation to that, the Children's Care and Justice Scotland Act, which has been passed by Parliament but not yet fully implemented. But when that happens, the age of referral will be for any child up to the age of 18. Once we receive a referral, we are under a statutory duty to consider that and to investigate to the level that we feel is appropriate. That investigation will involve us asking for information, often in the form of reports, quite often from the local authority and sometimes from others. Once the children's reporter has received enough information with which to make a decision in relation to the referral, they will make that decision, and essentially their question is whether the child needs to come to a children's hearing. And if the decision is that that needs to happen, it's based on two factors being present. One is that there is sufficient evidence to establish one of the grounds of referral. Those grounds of referral are listed in Section 67 of the Children's Hearing Scotland Act 2011. And if there is sufficient evidence of a ground of referral, the reporter must also be satisfied that the child is in need of compulsory measures of supervision. So the element of compulsion is an essential part of the decision making. If a decision is made that a hearing is required, then the reporter must draft those grounds of referral. The ground itself will be the starting point, and then the reporter will require to list a statement of reasons as to why that ground exists, setting out the reasons why and the evidence. And then they will arrange a children's hearing, and that's the next function of the reporter, which is to schedule and arrange the hearing, make all the sometimes quite complex arrangements for all of that to occur, setting the date, the time, the venue, considering who has a right to attend, and also considering who should attend, who might have a contribution to make in relation to the hearing, and also considering all sorts of factors like risk assessment, etc. At the hearing itself, the decision making is at that point passed over to the children's panel members, and I'm sure Mr. Jackson's given you a good overview of that. The reporter's role is there to provide customer care, to consider matters of health and safety, to support the fair process of the hearing, and to record who's present at the hearing, the decisions that are made. In relation to grounds of referral, if they are either not accepted or not understood by either the child and or the relevant persons who are attending the hearing, those with rights to be there, then the hearing may direct the reporter to apply to court in order to establish the grounds of referral. So that's the next part of the reporter role, is that we have to attend court, and sometimes we have to lead evidence in order to establish grounds of referral. And if those grounds of referral are established, then the grounds will be referred back to a children's hearing, which the reporter will arrange again. Further duties of the reporter are that any substantive decision that is made by a children's hearing, there are rights of appeal. Those rights lie with the child, with the relevant persons, and also with the safeguarder if there is one appointed. And if there is an appeal, then the reporter's role is to respond to that appeal in court. And just finally, I would say that that's quite a wide role. We cannot do that in isolation whilst we are independent officers. We absolutely rely on our partners. So partnership is very important work for us, both at local level and at national level. And we rely on our key partners for fulfilling all of our functions.
And when you talk about key partners, who are they?
Clearly, our partners in Children's Hearing Scotland would be an essential partner, local authorities, particularly social work departments, education, police, health. We have lots of liaison with advocacy groups, with legal representatives, with third sector organisations, safeguarders. I'm sure I've forgotten some, but a very wide partnership network.
I think the answers to this question may be similar groups of people, but in relation to the referrals that you receive, who are you getting them from?
We predominantly, we still receive the majority of referrals from the police. That's not necessarily in relation to concerns around the behaviour of the child, although it includes that. And sometimes it's referrals from the police in relation to welfare concerns. But we're getting an increasingly higher proportion of our referrals from social work departments. But we receive referrals from lots of different sources, sometimes we can even receive referrals from the family themselves. The child can refer themselves, actually, which has occasionally happened. So a very wide range of organisations and people who may refer a child to us.
We've heard the role of panel members is a voluntary role. The role of a reporter is not a voluntary role, is that right?
That's right, yeah.
And you tell us, I think, in your statement at paragraph 16 about the numbers of staff that the organisation has, and you tell us 277 full-time staff and 227 part-time staff, so we've roughly got 500 children's reporters in Scotland, is that right?
They're not all children's reporters. We have other roles as well. So in terms of children's reporters?
Yeah, there's probably about 130 children's reporters, but supplement roles around that core role supporting them. We have assistant reporters, we have senior practitioners, we have locality reporter managers who support that role of reporter as well. So the total of 500 is the entire workforce of SCRA.
I see. And in paragraph 17, I think you interestingly tell us that at the time of the pandemic, 89% of that workforce were female.
Yes, that's correct. And to this date, I think we're at 88% female workforce as well, even today. So that's a number that's remained consistent over that time, yes.
We'll come on, I think, to why that is perhaps important in terms of the impact the pandemic had later on. Prior to the pandemic, where did all of these members of staff typically work?
Typically, they would work in the various offices that we have around the country. We have offices in most local authority areas in Scotland, so we would typically be office-based. We would have occasions when people would work from home, and our reporter workforce had generally been provided at that point with a laptop, which proved to be quite fortunate for us. But not all staff. So typically we would be working in an office.
We've heard Mr. Jackson this morning telling us that children's hearings themselves prior to the pandemic typically took place within what he called, and I think you've already referred to, an estate, so sites across Scotland, and took place face to face. Are those the same places or same buildings as reporters are working from?
Mostly, but not all. So most of our SCRA offices will have a hearing centre as part of the building, but not all of them. And sometimes we have hearings in what we call outreach hearing centres, and that's really to try and make things more available, easier to get to for some families and others that might be attending hearings. But there's a real balance to be struck between the quality of some of those premises and the suitability for a children's hearing, as opposed to our own property, some of which we own, some of which we rent, but they're kind of bespoke hearing centres that we've created specifically for that purpose.
And again, we heard briefly this morning that children's hearings are heard are not buildings that are akin, for example, to a court building. It's something very different, and it's different on purpose. Can you tell us what hearing rooms and premises look like?
Yeah, so they're very specifically not in court buildings. I think actually under statute they're not allowed to be. To take place in the court or a police station, which wouldn't be appropriate. So our hearing suites have changed a lot over time, but typically you will have a hearing room and you will have waiting rooms, and ideally you would also have a room that would facilitate people having conversations, for example, with their legal representative or their advocacy worker. So some private space for people to have those conversations before a hearing. And also ideally, although not everywhere, we would also have a breakout room for panel members for their own comfort. And over time, those rooms used to be fairly standard rooms with a large table and lots of chairs around that table, and try to make informal, but over time, through feedback from children and young people, the tables have mostly disappeared, and there's now much more comfortable seating, and there may be a kind of small coffee table in the middle, but it's to create that much more informal feel. And we've decorated and listened to children and young people as to what would make them feel much more at ease when they come to a hearing. So our hearing rooms are really quite markedly different from what they were even 10 years ago.
We've already heard this morning about some of the people who might attend a children's hearing prior to the pandemic physically in person. In terms of the reporter's duties, who is entitled to attend and who might we expect also is invited to attend because they can contribute?
So clearly the child, and the people who are legally referred to as relevant persons, which is maybe not the most welcome description of people, but that would generally be anybody with parental rights, parents obviously, and others who may have parental rights, and also people who have a significant role in the upbringing of a child may be recognised as a relevant person. So these are the people who have a right to attend. Also, if the hearing has appointed a safeguarder, they would also have the right to attend. And obviously, anyone with a right to attend can also bring with them a representative. That representative can be someone to support them, or it could be a legal representative, or it could be an advocacy worker who might come with them. We would also expect the local authority to be represented at a hearing. Typically, there will be a social worker who will be working with the family, and they would understandably be part of the hearing. And generally, beyond that, we would look to other people who have a relevant part to play in the life of the child. And if they have some information or will bring some benefit to the hearing and to assist them in making a decision, then we will invite them to the hearing. And at the hearing itself, it's the chair of the hearing who will make the decision as to who is in the room and for what length of time. But those people who have a right to attend would expect to be in the room for the full time, with some exceptional reasons when that wouldn't happen.
So the reporter is in a position where they invite people to attend and tell them the date and the time of the hearing, and at the beginning of the hearing, the chair or the panel member who's in charge of the hearing, chairing the hearing, is able to make a decision about who is physically in the room when the hearing takes place.
Yes, the reporter will sets up the hearing, and that involves notification of all the various people who need to attend. Obviously, that includes panel members as well. But at the hearing itself, those people will arrive at the hearing centre. They'll be in the waiting rooms, and typically we would start the hearing with those people who have a right to be there, and we would add to that the social worker as well. And the chair of the panel will then decide whether they wish the other people present to come in from the beginning, or at what point and for how long in the hearing. It's the chair of the hearing who has the power to determine that.
We have heard a bit this morning about the nature of the orders that can be made at a children's hearing, and those being either a compulsory supervision order or an interim compulsory supervision order. Who is responsible for implementing those orders when they are made?
So that would be the implementation authority, which would typically be the local authority within which the child is living.
We also have heard, I think this morning, that orders are limited in time. Can I take it from that they expire and require to be renewed from the time they expire?
Yes. For a compulsory supervision order, it can only last for a maximum of 1 year, but may last for less than that. The panel members at the hearing can determine how long an order will last for, and an interim order prior to the pandemic and now since the pandemic it's returned to those normal rules, would typically last up to 22 days.
Now, as we know, there were national restrictions which were announced in March of 2020, which, as per your statement, changed the nature of children's hearings at that time. What did SCRA immediately have to do in the aftermath of that announcement?
Yeah. Do you want to take this one?
Yes, so immediately, I suppose the first thing we did was to close our offices. Starting, I think, from the week beginning the 16th of March, when it became apparent that the country was closing down, we started to put arrangements in place to send our own staff home. So to the extent they had access to laptops, they were able to do that. We also encouraged people to take home other kit that they would need for home working. For those of our staff for whom they worked from fixed PC terminals, of course, that presented a significant challenge. Although we did manage to deploy a stock of laptops that the organisation was holding as quickly as possible. But the first priority was to get our staff home so that they could work safely from home and, of course, look after their own children, because in that week we heard that the schools would be closing. It had an immediate impact on our operating model, so we went from a predominantly office-based organisation to a home-based organisation, and of course it had a significant impact on the delivery of children's hearings, which again went from a fully face-to-face delivery model to an entirely virtual model. At the time, we had been trialling a virtual platform, but that was still very much in the early stages. So from the first weeks, from the 23rd of March, we were able to convene very bare hearings. I think it was just a reporter and 3 panel members, but they were able to make decisions which kept in place orders which would otherwise have expired or lapsed, which meant that we could keep children protected by keeping statutory orders in place. That was then something that we sought to build on. So from the start of the following week, we were looking to obtain the views of children and families so that they could be fed into the decision-making of the hearing. And that was generally done by reporters speaking directly to the social workers who had that information and feeding that information into the hearings of children whose hearings had to go ahead. So again, I think that's a really good indication of the really good partnership work that was underway from the very start. From the 6th of March, we began to test a platform that allowed us to share papers, because at that point we were going ahead purely on the basis of verbal submissions. So that testing began on the 6th of April, and from the 13th of April we were able to test including additional participants on the virtual hearing platform. The note I have is that from the 27th of April we were sharing papers, and we were also holding virtual hearings with between 8 to 10 participants. So by week 6 of lockdown, we had a virtual hearing set up which allowed more participants and which allowed the sharing of information in advance of the hearing. I'd also say in relation to that, throughout that process, and before we could safely allow children and families into the virtual hearings space, because it was important that we had tested it, that we knew that it was operating well, and also that we could offer an experience to children and families that was satisfactory. In that scenario, we also relied on input from solicitors. So to the extent that solicitors were in contact with children and families, again, we relied on them to feed in the views of children and families to the decision-making of the hearing.
Touching on that period from when the hearings could not take place face-to-face, and you've spoken about a progression of the hearings and who has been involved and who's invited to attend them. Am I right in thinking then that there was a period of weeks where hearings took place only with panel members and a reporter?
Yes, initially we had, we didn't have the technology to allow more people to take part. The other thing that I think was really pertinent at that time was the ability of children and families to connect to virtual hearings. So not all children and families had access to a suitable device. They didn't necessarily have access to sufficient broadband or Wi-Fi. So again, part of the work that we did was supporting children and families to be able to participate within a virtual hearing setting, and to do that in a way that made it a satisfactory experience for them, because at this point the whole environment of virtual hearings was untested.
In the period where there was no ability to have anyone else apart from the reporter and the panel members, were there situations where there were children and young people who, or relevant persons, who were asking to be a part of hearings and they weren't able to?
I think that will inevitably have been the case, yes. But again, what we sought to do in that period was to ensure that their views were captured and that their views were shared with the panel members by the reporter. So we worked around the limitations of the technology to make sure that, to the extent views were being expressed by children and families about whether they wanted to go ahead, what the outcome of the decision should be, that information would be relayed to the decision makers. And again, that was where contact with social workers so that we understood the circumstances, and also contact with solicitors so that we could have that very direct understanding of the views in children and families were fed directly into the decision-making forum.
Could I maybe just add something, which is the decision obviously would be for the panel members at the hearing, but generally during that period they took a position of essentially trying to preserve the status quo, so not to make changes unless there was a really urgent reason why they would need to do so. And where those decisions were made, we did endeavour, where nobody was able to participate, we did endeavour to have a hearing at the earliest point where people could participate, where there was a need to do that.
Talking about that earliest point where people were able to join and able to participate, I think, Helen, you mentioned there being a number of, you said around 8 to 10 or participants who could join the virtual hearing at that time. Reporters are, of course, the people who invite whoever the participants are going to be. Was there a level of priority as to who would be invited, and what was that?
I'll maybe answer this one. Yeah, I mean, we had to create practice guidance throughout the course of the pandemic. We've provided you with some examples of that. It had to constantly change and evolve, as you can imagine, as things moved very quickly, and also as we developed capability in relation to virtual hearings. But generally, obviously, you start with those who have a right to attend the hearing. So 3 panel members need to be there, the reporter needed to be there, child relevant persons, and local authority representation, if there was a safeguarder, we would endeavour to make sure that they were able to join. And of course, legal representatives or other representatives, such as advocacy workers, would be prioritised. You then move into, more challenging areas where there might be people who have a really relevant part to play, but you are physically or technically restricted in how many people you can have. So sometimes those decisions were tough ones, but we did produce guidance in relation to that, which really was about preserving those with either a right to be there or a really essential role in the hearing.
Helen, you've already touched, I think, on difficulties experienced by families who might not have access to the technology to physically join those hearings. What other issues were experienced with virtual hearings?
I think, from the point of view of the platform, the platform that we used had to be secure. We had to use a platform that we could have absolute confidence in terms of data security. But one of the reasons that we limited participation to 8 to 10 people was really the limit at which we could have any kind of stability in the participants' experience of a hearing. I think it's worth saying that, and we all have to cast our minds back to 2020 at this point, but we have no control over the devices that people are using to connect into a virtual hearing. They could be using old devices. We didn't know whether they were using the most up-to-date operating system. We didn't know what the quality was of their broadband or their internet connection, and that's very variable across Scotland. So in addition to the platform itself, there were a number of additional factors, even just including people's confidence with using the technology, that caused a significant issue. I think we also recognised from the start that the children and families who we serve are often digitally excluded. These are families that don't have access to devices. They may have a phone, but they may not have access to laptops and iPads. So from an early stage, we worked with families to find out what sort of tech they had, to give them support in connecting with hearings, and also we provided data packages where that was required in order to allow them to connect, because obviously a video connection is quite data hungry. So we did work alongside them to mitigate some of the issues. There was another issue, not so much related to the platform, but related to virtual hearings, which is around privacy. When everybody comes into a hearing centre, we've got control over the environment. But when people are connecting from their own homes or public spaces, we don't have that level of control over the privacy and whether the proceedings can take place in private. We were also particularly aware of situations where there were particular vulnerabilities in a household. So, for example, where there had been domestic violence or coercive control, we have little control over what's happening in that household during a children's hearing. So there were a number of significant issues that we had to take account of in delivering virtual hearings during the pandemic.
When you mentioned, there are a number of things which you've raised which are interesting, and I want to touch on. You mentioned first the stability of the platform and the tech that was being used. What did that look like in terms of the hearing experience? Were people able to hear each other? Were hearings dropping out? Were participants dropping out? What were some of the issues that happened during the virtual hearings?
I think it was all of the things that you've touched on. The people dropped out, people couldn't hear. Trying to have that kind of continuity was extremely challenging. And as I say, we worked hard to address the issues as they arose. But I would say that with the original platform, we never got to a point where we were completely satisfied with the experience that we were able to offer. Just to kind of put it in context, of course, we used the secure platform initially. Then, of course, we had a return to face-to-face hearings in some form. So the focus, correctly as an organisation, came on reopening our hearing centres, preparing them for face-to-face hearings with social distancing. But when we went into the winter, and particularly when we went into the lockdown at the start of 2021, and we were increasingly reliant on virtual hearings, it became apparent that we were needing to look again at the platform that we were using. Another significant factor in that was, at that point, Scottish Government moved across to Microsoft Teams, and Microsoft Teams gave us was a significant game changer in terms of the platform that we could use and the number of participants that we could introduce. So from the start of 2021, we developed a virtual hearings platform on Microsoft Teams, and that is the virtual hearings platform that we continue to use.
You mentioned everybody is entitled or joined this hearing who is invited. I think, Alistair, you had previously mentioned in a hearing space, a physical hearing space, there were breakout rooms and facilities perhaps for people to have confidential and private conversations both before and after the hearing, but even potentially during the hearing. That facility was not available during virtual hearings, is that right?
Yes, that's right. Initially, we weren't able to offer the option of virtual breakout rooms. So what that led to, for example, was, solicitors having separate conversations with people on other devices in order to have that kind of connection and discussion in the course of the hearing. I should say that the platform that we're using now does offer that capacity. The other thing that I think was missing, which I think is really key, is the opportunity for families, children and families, to be supported ahead of and after a hearing by their social worker. So, those conversations that take place immediately after a decision are really important, and it was very difficult for those, it's more challenging for those conversations to take place when people weren't in the same space.
Reporters are obviously involved in these hearings and essentially the running and the fair process of these hearings. In terms of the staff and the children's reporters who were on the ground and running them, how did they find the virtual hearings?
Extremely stressful. They felt incredibly responsible for the experience that everybody was having. They put themselves under enormous pressure. They're very aware of the importance of the role that they do in keeping children safe. So they were highly motivated to continue to hold hearings for children who had to have hearings. But their experience of managing the virtual hearings was incredibly stressful for all of the reasons that we've covered. I think another element that I would add to that is people were doing this from their own homes. Our largely female workforce were doing it with their own children in their homes, so they had an obligation to their own children at a time that they were seeking to have hearings for children who are in the children's hearing system. And I suppose one of the things that we hadn't considered, because as I say, this was untested, was the impact on reporters of bringing a children's hearing into your own home and wanting to have that separation between work and home life, not wanting there to be photographs of your own children in the background while you were conducting a children's hearing. So I think altogether it's fair to say it was an extremely stressful and difficult experience for our staff.
We heard this morning from Mr. Jackson that his experience was that the length of the hearings was significantly increased during that period where they're required to be virtual. Was that also SCRA's experience?
Yes, very much so. I think a number of factors involved in that. I think firstly, getting everybody online at the start could take a period of time. So you weren't necessarily able to start at the appointed time. There was delay potentially as people dropped out and reconnected. And managing a virtual meeting, as I'm sure we've all discovered, is quite different to managing a face-to-face discussion. So I think there were additional challenges for the panel members and the chair in managing that virtual discussion compared with managing a face-to-face discussion. And again, this was something that was untested. We hadn't had the benefit of providing guidance in advance and thinking about how we could do this in a way that was satisfactory. So I think everybody did their best, but inevitably it was a suboptimal experience for everyone.
In terms of the particular impact on the children and young people who might be joining these hearings, who are of course the subject of these hearings, do you have any observations in relation to how their experience was?
I think that initially their experience would have been impacted by the experience of using the virtual platform. What I suppose I have an observation about the number of children who took part in hearings during the pandemic, because after the Coronavirus Act came into force, children weren't under an obligation to attend. So in that period, we know that a lot of children chose not to attend. I would also observe that our research team have conducted some research on virtual hearings directly with children, so we have some good information on that. And I think I would say that moving forward with virtual hearings, the situation around children and virtual hearings is it very much depends on the child. For some children, not being in the same room as people, not being able to see people, interact with them properly, was really unsatisfactory, and it's not something that they want to repeat. But there are other children who have said that actually being in a virtual space was their preference. They could look away from the screen, they could just have audio on, they didn't have to fully participate within the room, but they could still have the level of participation that worked for them. So I think it's a very personal choice between children, whether they will interact with virtual hearings going forward or not. And I suppose it's incumbent on us to make sure that we give children that choice going forward.
You mentioned there, I think, the changes in terms of the Coronavirus Scotland Act 2020, which I will come on to. But before that, I wondered if I could ask, at this time when there were restrictions in place which prevented really any face-to-face hearings taking place, are you aware of any difficulties in terms of the implementation of the orders that were being made at the hearings?
I'll maybe come in there. There were obviously some challenges, probably in relation to contact conditions. They were probably the most prominent issue that arose. I think it's fair to say that there was a lot of confusion around what was and was not allowed in relation to contact. Just to kind of clarify, a compulsory supervision order may contain a condition relating to contact between a child and another person, often a parent. So contact is very important for all sorts of reasons. And we did create our own guidance in relation to contact to guide our reporters in relation to this issue. But it definitely was the case that there was confusion and perhaps some different interpretations amongst different organisations around what was and was not permitted.
When you say different organisations, who do you mean?
I guess what I'm probably referring to is that there are 32 local authorities, and different local authorities would perhaps interpret things slightly differently. Everybody was trying to do their best, as always. We had a very clear view within SCRA that if there was a contact condition in relation to a compulsory supervision order, then there was no legal reason why it should not be implemented. It should not be observed, and we created some clear expectations around that. I know that there was Scottish Government guidance which also indicated that an order is a legal order and must be adhered to. I know that there was also some Social Work Scotland guidance which said something very similar. So these were all, I think, attempts to try and gain some national clarity over that issue. I would say that in relation to contact, before the pandemic, we had a protocol agreed with local authorities, which essentially was that if there was a contact condition, if that contact was not being provided, was not being supported, that there was an expectation that the local authority would, in very short timescale, request a review of the compulsory supervision order in order that the hearing could consider this and that the family would have an opportunity to influence any decision around that. We did recognise that we had to slightly soften that approach because of the practicalities that were around at that time. And what our guidance essentially said was you should be implementing the order, the condition. However, if the family are prepared to agree that there is some other arrangement, then that's an acceptable position given the circumstances that we were all living in at the time. But if the family were not in agreement, and if that alternative arrangement was going to be longer than a short-term one, then the local authority should ask for a review.
Were there situations where there was a tension between a family seeking contact and expecting contact to take place as per the terms of an order, and an implementation authority saying, we don't think that contact is able to take place at the moment because of restrictions?
I'm quite sure that there would have been those circumstances. Anecdotally, I would say that they did exist. I guess local authorities would probably be in a better place to provide more accuracy around that.
Helen, you mentioned the changes brought about by the Coronavirus Scotland Act 2020, and I think we've heard that was enforced from the 7th of April 2020. I wondered, did SCRA have any input in relation to those changes and what they were going to be?
Yeah, I'll probably answer that. It's kind of within my responsibility. So yes, within Scottish Government there is a children's hearings team, our sponsor team, and we have a very good relationship with them, and they were incredibly supportive throughout the whole pandemic, and right at the very beginning came to us more or less straight away to talk about what measures might be helpful in order to allow us to get through what was clearly going to be a difficult period ahead. So we were one of a number of organisations that were spoken to, and others that were spoken to included children's rights organisations. I believe Children's Commissioner, I'm sure, would have been consulted too. But certainly we were asked for our views and asked what might be helpful in order to, I guess, ensure that we kept children safe in relation to the statutory system. So I think we would reflect very positively that we did have that opportunity to influence. Of course, some of the things that we may have suggested may not have made it into the legislation, but largely it was around giving us some flexibility around timescales was a kind of essential part of that.
My next question was going to be how helpful did SCRA find those changes?
They were enormously helpful because of the flexibility. When what you're having to do is essentially prioritise making sure that no order was going to expire, which would have left a child potentially very vulnerable or at risk. So, and at a time when you're trying to deal at personal and professional level with this kind of new world that we were all living in at that time. So the flexibility and the changes were enormously helpful. What I would say though is that we were very clear, and it was very clear very early in the implementation of those provisions, that we should only use them when we absolutely had to use them. So, and there were periods during the pandemic where we used some of them quite a lot, and other periods where we used them less often. Some of them were quite directive, so there wasn't any discretion over them. For example, one of the changes was that if a child protection order was obtained, normally we would have a hearing on the second working day after the order is implemented, and the Coronavirus Act removed the need for that second working day hearing. So that's a directive order, so we didn't have second working day hearings. But others were discretionary, such as allowing an order effectively to continue for 6 months beyond its normal expiry date. And that was something that was within largely our control as to whether we used that provision or not. So some provisions were directive and some contained an element of control discretion.
You mentioned, I think, in your statement that there were times when orders were extended as per that discretionary decision that you had, but that families were given an opportunity to request a hearing at that time if they felt there was a need for it to go ahead. How did that process work, and was it used by families?
Yes, it was used by families. I don't have numbers, but my sense is that it wasn't used a lot, but definitely some families did take that up. It was done in a variety of ways. Sometimes, we sent a letter to children and families to advise them that there is this provision, we are intending that we will use this provision, but that you can let us know if you would wish to have a review earlier than that, and we will do our best to arrange that for you. But also we were having conversations with social workers and sometimes with solicitors and sometimes advocacy workers to determine whether there was a need. Because sometimes we were arranging hearings within their kind of normal time period because there were other issues that we felt required the attention of a hearing. So, for example, that an order may require to be varied, or sometimes that an order was no longer required, and a child should only be an order for as long as is absolutely necessary. So there were a variety of reasons why we may have chosen to arrange a hearing within its normal time scale. But we provided on a regular basis, I think it was every 6 weeks, we provided a report to the government of our use of the various provisions. Those reports are publicly available. And you can see within that, there's a lot of data in there, but you can see how the use of that particular provision went through some peaks and some reductions in its use. And that really reflected the kind of movement of the pandemic and the increase and decrease of restrictions.
Talking about that increase and decrease of restrictions, we've already mentioned there of course was a time when face-to-face hearings were able to resume. First of all, do you recall when SCRAL learned that face-to-face hearings would resume?
I pick that one up. Yes, so I think the First Minister, I think it was the 21st of May, was outlining Scotland's route map to recovery, really at part of that, and as part of the number of restrictions that were outlined in that route map to recovery, there was a statement that face-to-face children hearings would resume at that point. And as an organisation, whilst we were absolutely welcoming all of the route map to recovery, that was probably the first time we'd heard that face-to-face hearings would resume. And we quickly had to turn our attention to that. There was a bit of a ripple of anxiety probably across the workforce, given there were pretty strict restrictions still in place and what that meant for them. But I think we were in a fairly good position. We'd started prior to that anyway, starting to think about our own opening. What did we need to do when we did get the go-ahead to open back up? So we'd already started some of that planning, including working with Public Health Scotland on risk assessing opening hearing centres, risk assessing opening our offices. So we were in a good position to respond to that. But I would say on the day it was a bit of a surprise to us at that, but we were ready and able to move forward. And then we started a whole kind of planning of how do we phase those offices opening, where do we start, what are the technical aspects we need to do that, what about social distancing, what about taking desks out, what about testing water, because it'd been closed for a number of weeks, months. So there was lots that we had to do and plan for that.
I think you mentioned in your statement one of the things that happened, at least in some hearing centres, was that walls were taken down in order to expand the hearing room available to all of the participants.
Yeah, some of our smaller hearing rooms, we would only have been able to get 5 or 6 people into the room. If you have a reporter and 3 panel members, that doesn't leave a lot of scope for other participants. So in a number of occasions, we took walls down. We repurposed office space, so we turned our office space into hearing centre space and flipped staff into the hearing centre. We also managed to identify a couple of big external spaces that we could use. So in one case we used a church hall, which gave us access to a space in which people could socially distance but come together for children's hearing. So there were a lot of creative solutions that we put into effect in order to get back to face-to-face hearings.
Similarly to perhaps the early version of a virtual hearing, were there a restriction or at least an ethos of trying to keep the number of people at a hearing to a minimum at that early time of face-to-face hearings? And if there was, then how did you decide again who was going to be present?
I mean, that was absolutely inevitable, because even in our bigger hearing rooms with 2 metres social distancing, there was a restriction on numbers, and I think the practice direction was amended to take account of that.
Yeah, we again, more practice guidance was required, and there was a variety of different considerations. One of them was how many people need to attend this hearing, how many people is it pretty essential to have, and if that number was above a certain level, then we could give consideration to whether that would actually be better on a virtual platform or as a hybrid hearing, where there would be some people in the room and some people would join virtually. So there was lots of options. If the decision was, based on a number of factors, that actually this is a hearing that is best done as a face-to-face hearing, and a crucial factor was, would this actually be more helpful for the child or for relevant persons for their participation, then again we would return to looking at the same as I indicated before, those with who are absolutely necessary to be there, those with a right to be there, and then try and build in as many others as you possibly can, and in the order that I gave before.
All of this, all of these hearings, of course, are continuing to take place at a time when lots of other things are closed, one of those things being school. First of all, I wondered if staff had key worker status during the pandemic.
Well, key worker status was a bit of a challenge for us in the early stages of the pandemic. We didn't get status 2, key worker status 2, until December 2020. So up until that time we were working on the basis we were key worker stage 3, which gave you no access to any kind of support really in terms of schooling. And as you can see from an 89% female workforce, that there's lots of homeschooling going on for our female workforce there. So in December we were grateful to get key worker status 2, which gave us that access to school places, which were very limited across Scotland. However, even getting that status wasn't easy for our staff to get places at all. We were still up against a number of challenges because of the limited places and the prioritisation perhaps that local schools put on those places as well. So we heard lots of stories of not getting access at all, to SCRE having to write and vouch for individuals with that key worker status too, and where places were limited, they were prioritised, where maybe 2 people in the household had key worker status too, or if there was an ability to work from home, you were kind of moved from that prioritisation. So it was a challenge for our workforce really to be able to deliver their role from their home spaces with children around and having to deliver homeschooling as well at the same time. So that was a real challenge for our workforce. And we had real examples of, people starting their work at 6 in the morning before children got up in the morning, and then dealing what they had to do with during the day, homeschooling, caring, and then on at night. So that was a real tough day for individuals on the regular. And even for those staff that didn't have those caring arrangements, they were picking up work for their colleagues who did have. So people were absolutely committed to doing what they did. They were incredible during that period, to be honest. And we had to wrap lots of wellbeing support around them to do that. And managers, spent a lot of their time doing that on a daily basis. So it's hard to remember back how difficult it was for people during those times.
I was going to ask, did it have an impact in terms of staff wellbeing, and have you as an organisation been able to recover from that impact?
It certainly did have an impact at the time. We tried to give as many messages and permissions to be able to contribute as much as you could contribute, but at the same time recognising that staff had those caring arrangements and had those other responsibilities that they didn't have before. So yes, we implemented lots of different wellbeing aspects in terms of wellness plans, one-to-one discussions with managers, daily contact with managers, and I think it took us a long time to recover from that actually. On top of that, we had daily change coming, restrictions changed very regularly, so we were constantly advising and updating how people should work, how they should interact, how they should do that. Our systems were changing, moving from face-to-face to virtual, so there was lots of change. So there was a bit of change fatigue over that period of time, on top of the absolute commitment of our workforce in terms of making sure every child was kept safe.
One aspect which I don't think we've touched on yet, and which I think is important, is that the role of the reporter, or the Scottish Children's Reporter, administration as a whole doesn't just extend to the conduct of children's hearings, it also extends to conduct of work in court. What happened to the cases which were supposed to call during that initial period of lockdown?
As I recall, the courts essentially took that kind of emergency position, which was, again, it's about preserving proceedings that are in place, but not allowing things to proceed. So any proofs that were due to proceed were essentially cancelled, and orders made in order to preserve the position. So, and of course, everything had to then be switched again without being able to physically attend courts. So, in relation to court work, same as hearings, we had to just constantly monitor, review and adapt and be creative, and were very much led by the guidance and position from Scottish Courts and Tribunal Service in relation to how all of that operated. But certainly at the initial stages, any substantive proceedings were essentially postponed, deferred.
You say in your statement, I think, that there was then a change in how cases were conducted. Some hearings took place virtually, and also I think you say that the court would rely more on written statements and written information before it. I wondered how you think that impacted on the cases that were being heard in terms of grounds of referral.
I mean, there are probably some positives and negatives in relation to that. I mean, when you do all of your preparation and provide all of that information to the court, then that kind of front loads a lot of the hard work and can often lead to matters resolving. So there would be a benefit in that regard. But of course, the inability to, for a long time, to be able to have actual proof proceedings go ahead, then that inevitably would build in delay. And of course, delay is something that we try to minimise as much as possible, because delay in a child's life is proportionately even more significant than delay in an adult's life. So for the benefit of the child, we would do everything possible to minimise that.
It's also worth saying that I think a lot of our cases settle within the court building. So when everybody is together for a calling, you've got relevant persons, you've got parties, you've got solicitors, and those discussions can take place and decisions can be reached. You can actually get to a point of settlement, and we did have a challenge when everything was taking place virtually, getting everybody together in the room to have those discussions.
I think, Alistair, you mentioned delays, and something you acknowledge in your statement is that court delays are not something which were unique to the pandemic, but you tell us an anecdote about a case which you understand took 3 years from the grounds being referred to the court to then a substantive decision being made as to whether those grounds were proved or not. Yeah. Was that a delay that was caused by the pandemic?
It was impacted by that, but I would say that probably the principal reasons were probably not related to the pandemic for that. It was quite complex. I mean, that is obviously very exceptional, but not unique. There are proof proceedings which can take extraordinary lengths of time, and there are multiple. Yes, indeed, my lord. And there are various different reasons why that may be the case, and a lot of them at play at the same time that all kind of conspire together essentially to cause such a significant delay. But you can only imagine the impact on a child's life of waiting that length of time for a decision to be made.
You also tell us in your statement, I think, that the number of children and young people referred to the children's hearing system and therefore the number of grounds of referral at that time was reduced quite substantially during the pandemic. And I wonder if you might be aware as to why that might be, why there were less referrals to the system generally.
Yeah, certainly we received less referrals during the pandemic period from what we would normally receive before, and it has built back up again since the pandemic. As to why, I know that you had some of this information from the panel from Social Work Scotland in earlier days of the inquiry. Children were not being seen. Schools being closed, schools and nurseries being closed was a huge factor in that. So, universal services which would normally have contact with families were not having that physical contact, not having eyes and ears on children. And also, a number of our referrals would be because of incidents that might take place in the community, and of course with movement restrictions those incidents were not occurring. So those would be some of the reasons why. Just that kind of lack of contact and I guess lack of awareness. Children were undoubtedly in incredibly vulnerable places during that time. Some of them in households where there were multiple risks around for them, and the kind of lack of access to school, nursery and other people who might support the family would undoubtedly have put them in a very vulnerable position.
That, I think, takes me on to the paragraph in your statement where you raise lessons to be learned from all of the changes which took place during the pandemic, and that, I think, is one of the things that you touch on, that there were, of course, safeguarding implications to some of the decisions that were taking place at the time. What lesson are we to take from that, do you think?
I mean, I don't want this to sound like it's being incredibly critical, because you have to recognise that you have to look through the lens at the time that we were living in. So those who were making the decisions had an incredibly difficult job to do. But, when you're making decisions such as closing schools, if you had the time and the space to do a proper impact assessment, and if you had the time and the space to engage with children and ask them, what impact would this have on you? And is there anything different that we might be able to do? Because you have to weigh up what is the greater risk. There obviously was the risk of the pandemic spreading, a very real physical risk to the health of the nation. But there are other risks at which the inquiry will have heard from many different people. And for children, that lack of access to education, to all of the social and professional support that they would normally have, their kind of normal life, the right to play, it was an enormous impact. So for me, it would simply be about having that full impact assessment at the earliest possible stage. I'm sure they were doing that, and those were incredibly difficult decisions to make, so don't want to be overly critical, but that was the one to me that probably had the most significant impact in relation to children, and obviously had a knock-on impact on those caring for the children too.
Helen and Susan, we have only a brief moment left, but I wondered if there were any reflections which either of you had in relation to lessons to be learned.
I mean, I think Alistair's absolutely covered that, and the impact on workforces as well as part of that, in terms of picking up children not being at school was a huge lesson for us as well. In terms of the impact on the workforce, and how that impact is then taken back into home life, and how that then impacts there as well. So I think that the far-reaching impacts from what Alistair's described. So, and I suppose from me finally, just to recognise that the real hard work that our workforce did during that period, and we're very grateful for that.
Yep. I mean, I think in terms of continuing and lasting impact, a colleague of mine is very fond of the phrase, never waste a crisis. And what I would say is that the change that we had to not embrace, the change that was thrust upon us at pace throughout the pandemic, has meant that we are a service which is now much more resilient, much more adaptable, and I think that is serving us well. The big thing was the impact on our workforce. We're now trying to distinguish change from crisis management. The pandemic wasn't change, the pandemic was crisis management. We took a real dip in morale as an organisation as we came out of the pandemic, and we're working back through that, because clearly we remain in an environment where change is going to be a constant. But I think we are a much more resilient and adaptable organisation than we were. I think across the children's hearing as a whole, I would say that we see that. But absolutely, that's testament to the hard work and the dedication of our workforce.
Thank you very much. That just leaves me to thank you and ask if His Lordship has anything to add.
Thank you very much, Ms. Traynor. Can I just say, particularly to Mr Hogg, what you said about the impact on children echoes, reinforces what has been said by many others, and seems to me to be very sensible, if I may say so. But also, it could be reflected in better planning, and perhaps one of the main things we'll have to take out of this is thinking about pandemic planning in a far more structured and detailed way. But thank you all very much for your evidence.
Thank you.
Very grateful. 1:45.
All right.